May I have your attention, please? Because this is the fifth and final night of the 1980 Criminal Law Evening Session series in our CLE programming, I am taking this opportunity to repeat my thanks to Brian Greenspan and Mike Moldaver for chairing and putting this series together. As you know, this is the third year in which they have done so, and I find tonight that they are already talking about the 1981 series. I'm not going to tell you more than that, but they have good ideas in their mind. Now, I also take this opportunity to thank, on behalf of the Law Society and indeed of myself, all of the persons who have or are participating in these programs, and I include the participants sitting behind me who are going to spend the next couple of hours with you. We are much indebted to members of the bench and of the bar who enable us, the Law Society, to do what we think we should be doing, and that is offering programs of this caliber to the interested members of the profession. Now, with that, I'm going to hand the proceedings over to Brian, who will introduce your panel, and you can get on with tonight's business.
The panel for tonight is moderated by Heather Smith, graduated from Queen's University in 1971 and called to the bar in 1973, and is prosecutor with the Federal Department of Justice. That's the extent of Heather's curriculum vitae here, which is consistent with the speed at which she argues her cases in the Court of Appeal and at trial. To her left is His Honor Judge Wren. There was a formal curriculum vitae handed in, but as well there's a handwritten curriculum vitae that Judge Wren handed me, which simply says BA in Philosophy at St. Michael's College, University of Toronto, 1949, Osgoode Hall, 1954, practiced in the firm of Cutney and Wren, 1954 to 1969, appointed to the County Court Bench of the Judicial District of York, January 1970, married to Jane. I can't read his writing. Jane Pratt of Orillia in 1954, and the result was 6 children, and that his wife was agreeable to divorce at any time, provided that he took the 6 children. To the far left, Bill Mackie. Bill was called to the bar in 1956 and has practiced criminal law exclusively for the past 15 years in Brampton, a lecturer in the bar admission course, part-time Crown attorney, not only a leader of the bar, defense bar of the Judicial District of Peel, but certainly one of the leaders of the bar in the province of Ontario. To the right of Heather, Clive Bynoe, graduated from McMaster University in 1953, attended Osgoode Hall and called to the bar in 1957, became a Queen's Counsel in 1971, is also a member of the bar of the Northwest Territories, which leads to a very active criminal practice in the North. Lecturer in criminal law and procedure at the bar admission course for 20 years, a lecturer in criminal law and procedure for the Federation of Law Societies, past president of the Criminal Lawyers Association, counsel to quite a number of royal commissions, and a bencher of the Law Society of Upper Canada. To Clive's right, Dick Chaloner, called to the bar in 1961, assistant Crown attorney for Simcoe County 1963 to 1966, has been Crown attorney of Wellington County since 1967, regional Crown attorney for West Central Ontario since 1976, Queen's Counsel 1972, and president of the Ontario Crown Attorneys Association. Your panel on conspiracy for tonight.
Brian, as you... Brian, as you indicated in your opening remarks, the four panelists tonight are singularly suited to speak on the practical issues that arise during the course of long trials, particularly long conspiracy trials. Mr. Bynoe and Mr. Mackie are both sole practitioners, distinguished practitioners at the criminal bar, bringing with them a wealth of experience. Being sole practitioners, they're particularly aware of the problems that arise in a one-man practice when a long trial is undertaken. Mr. Chaloner is a Crown attorney for a number of years, and all Crowns are solo performances, is particularly aware of the problems that arise in long trials. And His Honor, Judge Wren, with ability and patience, has presided over some of the longer conspiracy trials in this jurisdiction. I have been asked by all the panelists to indicate to you the approach we propose to take tonight is a practical one rather than a legalistic one to the problems we're going to deal with, because that was the tenor of the direction we were given. They can bring their practical experience to bear on the problems that will be considered. We propose to review the four areas that are covered in the program that was distributed to you, and if moments of inspiration dry up, we propose to open to questions to the floor. So if any of you have any questions, you'll have an opportunity to put those questions to the panelists. Dealing first then with the issue of severance and conspiracy, I think it would be fair to say that it's been the subject of some judicial comment, most of it critical and disapproving, that conspiracy and substantive charges really ought not to be tried together. Nevertheless, it's undoubtedly legal that this be done, that both conspiracy and substantive counts appear on the same indictment. I wonder, Mr. Chaloner, if you direct comments as to when it is that you proceed with a conspiracy count rather than a substantive count.
First comment I'd make is I wonder if the person who set this up had something in particular in mind when he placed me on the far right and Bill Mackie on the far left. I also note that when I look along the desk here for the panel that we're all using Dave Doherty's article on conspiracy, which I suppose still proves that all good law comes from the Crown. Also, I'm here supposedly because of long trials. I should tell you that in Wellington County, a long trial is 3 days. And after that, if we can't plea bargain our way out of it, we withdraw it and go home. Anybody that gets into a trial that goes on for 6 or 7 months, I think, needs to spend a short time in the Clark Institute. Either because he got into it or as a result of the long trial. What I did want to outline is the circumstances that I would see the Crown using the charge of conspiracy. I think the classic example and the best justified one is where there is only an agreement and no substantive offense was carried off.
And no evidence.
No, we'll get to those cases in a minute. that comes under hiding three. The classic example of that would be, I suppose, Guy Fawkes, who didn't manage to carry off the crime that he was intent upon committing, but it would hardly have seemed sufficient, I think, to the people of England to have charged him with possession of gunpowder or break and enter, so that the crime of conspiracy would be rolled out to get him under, I suppose, high treason. The next area I think that the Crown would use conspiracy, and quite legitimately, is when you're dealing with a organized crime and you want to get as high up the criminal ladder as you can, the use of the conspiracy charge will often get you closer to the top than trying to stick to the substantive crimes that are committed by the less important persons. Another area that I think that is connected to that is where you want to give an overall view and you want to demonstrate the size of a particular operation. You want to effectively establish the roles of all the participants and put those roles in their proper perspective. Again, I would think that the conspiracy charge, the conspiracy trial would most effectively carry that across. Now, we have the fourth one where you would want to use declarations and actions of co-conspirators against each other. I realize that that is not limited to conspiracy, but I think that most people would agree that you can more easily get away with it in conspiracy than you could if you stuck to the aiding and abetting or counseling. The same thing could be said again for association evidence, although there again clearly that is not limited to conspiracy. Now, the time that I like most to use it is the one that my co-panelist referred to as the time when there's really not any evidence. That, I would say, is the time when there isn't enough evidence to establish one substantive offense, but that you have evidence almost establishing a lot of substantive offenses. This is the type of case that could be characterized as the web of conspiracy. The decision I like best in that area is Saskatchewan Court of Appeal. It's Rex and Gotteslag in 1951. That was a Western case involving persons who were breaking into service stations, a gang. And the police evidence through surveillance was that these people would go to a small town. In fact, I don't think it was through surveillance. I think it was through later investigation. These people would go to a small town, check into the hotel. That night, 1 or 2 gas stations would be knocked over. There'd be no sign of forced entry. It was a slip lock entry. When they added up all their evidence, they could only connect them with 2 out of many service station break-ins. They had arrested them and found in their possession burglar tools, i.e. celluloids to slip locks and a couple of other items. They could only had a fingerprint, I think, in the one service station. I'm not sure what there was in the other, but really not enough to nail these people with one of those substantive offenses, probably. And had you nailed them with one, it probably would not have led to a very substantial sentence, and certainly would not have placed before the court the size of the operation. They successfully prosecuted on the basis of conspiracy, so the court could put all the evidence together and say that the only conclusion you could come to was that these were the people breaking into the service stations. We did the same thing a number of years ago up in Western Ontario. We had 2 separate gangs breaking into men's clothing stores. And by breaking into a men's clothing store, if you do it right, you can easily get $20,000 to $50,000 worth of stock out in about 15 minutes. These people were doing just that, and it was a considerable problem. We, through investigation, were able to place these people in and around the clothing stores when the break-ins were occurring. We were able to place their car and often them, or one or other of them, in an alley behind the store prior to the store owner discovering the break-in. We're able to place some stolen property, some stolen clothing from other break-ins where they were not observed in their possession. We're able to go to trial on that and convict them all of conspiracy to break into these clothing stores. I don't think I could have convicted any one of them on any one of the offenses if we had just gone on the substantive count.
I'm wondering if in the course of considering the charges, it's possible to lay a conspiracy charge where the conspiracy will take a number of weeks at trial, and you're also laying a substantive. Now, your substantive charge may be a little weak. Is there any possibility that by proposing to proceed on both at once, it might be regarded as a form of light blackmail, that the accused plead to the substantive offense so that he doesn't have to spend weeks and months at trial?
Well, I thought we did that all the time. I suppose it can, and there are cases, certainly, where I've seen us join the substantive count with a conspiracy count. The justification for the Crown in doing that is to say that the court may very well not find the large conspiracy that we say exists. They may find that only the one person is involved, therefore there cannot be a conspiracy. There isn't sufficient evidence to involve the other 2. Therefore, we feel the substantive count should be available so that we don't have to go through it all again to convict the person of the substantive offense.
Do you ever-
I honestly don't think I've ever just thrown the substantive in to give the back door for a plea of guilty.
Do you, excuse me, do you ever feel that on conspiracy trials, there is a danger that that might be the case?
You mean that somebody would plead guilty?
That the pure length of the conspiracy trial would prompt an accused to consider pleading to a substantive count?
Now he's got legal aid.
Well,
Is that a possible weakness of a conspiracy
surprisingly, the
trial?
comment came from the left end of the panel, not the right, that not if he's on legal aid. But I think that is that's an issue that Mr. Bynoe might want to speak to on that.
Mr. Bynoe?
Well, I don't think there's any doubt about it.
I didn't think you would.
Never. The power of the state to steamroll the individual's just been increasing no end since about three things. One, wiretap. Two, the ever-inventive mind from the Sermon on the Mount at 18 King and sometimes down at Toronto Dominion Centre, where their fanciful ideas and textbook ideas of the administration of technical law, way conspiracy, has little fantasies that they creep in and throw at you, and by the time the accused is waking up to what the hell's happened, if he's an individual, and if he's a man of moderate means, he's lost his house, his home, and he's looking for legal aid by the time the Crown is still calling the similar acts. The second thing, of course, is the advent of legal aid. They then have the power to fight the state in a different right, and it just seems to me that you get people who are so bloody academically inclined that they think the administration of justice is designed to have some textbook case that they have their name on and it's reported.
Would you agree that there may be a place for proceeding on the conspiracy charge if that is the only way available to get the principals?
You just defined it then.
Is that
It's the only way. Yes. And if it is of sufficient public importance that you proceed in that fashion, and that there are no substantive counts that you can lay and be reasonably assured of a conviction within a reasonable length of time, then I suppose there's no alternative.
Well, would you not agree there are a number of situations where to proceed on anything other than a conspiracy, to confine it to simply substantive counts, would really only be touching the tip of the iceberg, and the wider character of the real offense would be lost unless the conspiracy was proceeded with?
Well, it's like trying to melt the iceberg from the top down. Why don't you chip at the bottom and see what happens first?
It's an interesting observation.
It's not difficult to see who acts for the people at the top. Anyway.
I didn't act for Mr. Catroni.
So you feel, notwithstanding the fact that it may be a fairly onerous burden, the trial may take some time, that there are instances where a conspiracy charge must be proceeded with, notwithstanding the complexities of the trial and the length of time it may take.
And they're very, very limited.
And presumably the principal obligation of the Crown then would be to ensure that they only go forward in those cases that most deserve it and merit it.
Well, I think if they applied the English test and they can satisfy the judge of that, then I think perhaps they should consider.
Could I just interject that I would agree to some extent with what's been said, and particularly I think the Crown has to consider whether the price is going to be worth the finished product, in the sense that why spend 6 months of your resources in a long, drawn-out conspiracy trial that benefits nobody except perhaps the lawyer that's on legal aid and keeps him fully employed for that 6 months. And at the end of the 6 months, you get a 30-day sentence or probation for some fellow. I think that's madness.
So along with the only being able to get the principals and the fact that it would have to be a serious offense before you proceeded with it, the end has to be worth the effort. The difference between any possible substantive offense and the conspiracy would have to be worth the difference of time and money expended.
Exactly.
And do you feel that's a pragmatic approach that's taken by most Crowns in your experience?
I think so. I'm not that terribly familiar with what happens down here, but from following in the papers, I don't think I see any minor stuff going through the courts on conspiracy, but other people may have other opinions on that. I don't see it.
All right. Faced with the prospect of a long and costly trial for your client, let's take a practical look at the application of the rules for severance with respect to co-accuse on a single conspiracy count. With the current state of the law, what are the likely areas that you'd be able to secure severance on, and what's your likelihood of success? Your Honor, would you?
Well, first I'd like to also comment about how I'm placed and why. Dick did. I don't see why I shouldn't be given the opportunity. There was a conspiracy, I believe, between Bill Mackie and Brian Greenspan on deciding who to choose among the judiciary that had experience in long conspiracy trials, and Bill wanted to use this opportunity to have a go at the judges, so they picked the most vulnerable patsy of the bunch. That's how I happen to be here. I'd like to go back a bit, if I could, please, Heather, on the business of severance of counts, of which Dick has spoken. I don't think that there would be any practical problem at all in getting any judge in this jurisdiction, and I would suggest Canada, to sever the counts. The complexity of the charge itself now indicates that, and in England, in a case as long ago as 1965, Regina and Griffiths, the Criminal Court of Appeal made that observation, and then in 1977 it became a rule that the Crown could not proceed in the same indictments in Britain, in the same indictment on the conspiracy and substantive count without prior judicial approval. So I think if you are faced with asking for severance in the matter of counts, that you'd be assured of success. On the topic we're on now, the severance in respect of separate trials for the accused, I think your chances of success would be very unlikely. The arguments that I could possibly think of is where one accused, as part of his defense, means to attack another accused, or where you have a confession or statement of one accused coming after the conspiracy and therefore not admissible against the others, that you could move on that ground. But I doubt that you'd have much success. The Lord Goddard made that plain in an English case, Regina and Gronkowski, in 31 criminal appeal reports. I think that the only ground really with much merit in it is the one concerning the confession, and there you're simply, I think, going to be faced with the ruling that the judge will carefully warn the jury that the statement may not on any account be used against any person except the accused making it. There is, of course, another procedure, and that is, you may be successful in that, and that would be to vet the confession so that mention of the other co-accused is removed. If I might, could I address myself to something that was said there about the Crown bringing, this is from experience, about the Crown bringing conspiracy counts. There has been judicial censure of the Crown for bringing a conspiracy count where the – offense was proved of conspiracy entirely from proof of the substantive offense. Now, that doesn't very often occur. Clive, I think, hit what the reason the Crown does bring them today, and so did Dick, particularly because of the activities of organized crime, the use of wiretap, and because, as you know, a person may be a party to the conspiracy even though they played a minor part and came in at a later stage. In our experience in this county, I only know of one case that I could have criticized the Crown for bringing the conspiracy charge when they could very well have gotten each of the accused on substantive counts with the same penalty. And Pat Duffy's here, he prosecuted that one, he'd remember, Tyrrell and Vavala. However, that's what I thought about the Patsy Perry trial, which had gone on that one started in September, and as Mike Dambrot and Mr. Reisman, who were also survivors of that trial, will recall, it ended in the end of February. And that's what I thought about that case for a long time until I really discovered what had happened. It was called the Patsy Perry case, but Patsy died between the preliminary hearing and the trial. And so it just went on as a conspiracy. And the Crown, I came to the conclusion, was originally justified in laying the conspiracy because Patsy was the guiding and directing influence who stayed in the background and was seen and heard to do nothing. Another example of where I think the Crown was perfectly justified in bringing it was that case of Judge O'Connell's, the Barry's Bay case, where they had all the ingredients and all the pots and pans, but the police raided a day or two too soon, and they hadn't started to do the cooking. And so that was a proper place to bring one.
Your Honor indicated then that, in your view, there would be no difficulty getting severance for a conspiracy and a substantive count. Would that be true even if the substantive count was clearly an act in furtherance, but a very minimal part of the wider character of the conspiracy?
Yeah, exactly. If we'll get to it later, but if you have to give a charge on conspiracy, as complicated as they are, and now, since the directives on those charges by Mr. Justice of Appeal Martin in both Barron and Wertman and in the Manny Mota situation, I think you can be sure of severance on counts, but not of accused.
Mr. Chaloner, do you think it's reasonable that, notwithstanding possible post-arrest statements and some prejudice that may arise to accused, that there should be a fundamental underwriting principle that joint participants in a conspiracy should be tried together? Are there social policy reasons and good judicial reasons that should be the case?
Well, yeah, I do. I think the cases all recognize that the very nature of conspiracy is going to lead to joint trials, that you're trying people, the crime itself involves joint accused. An advantage, you would avoid inconsistent verdicts. And also, I think that where there is severance, there's going to be delay, there's going to be inconvenience to witnesses having to come back again for the next trial. And your objections, I think, to being tried together are largely overcome by accepting that juries are presumed to follow the law as the judge charges them. My understanding is now that the most likely area in which you would get a severance is dealt with in Giuliano in the Supreme Court of Canada in March of 1979, That is that if you have conspiracy and your evidence is very weak against one of the conspirators, and one of the co-conspirators has given a statement that implicates the man against whom the other Crown evidence is very weak, that it would be proper in those circumstances to have a severance. Now, you're obviously at the beginning then are going to have a mini trial in which the evidence is outlined to the judge, and that is demonstrated, the fact that the Crown's evidence independent of this co-conspirator's confession is rather weak, and therefore it's not fair to the one person to be tried with the others. I might myself in a situation like that take a run at getting the fellow that confessed in the box at a separate trial anyway and see if he'd repeat it all.
Does anyone else have any other comments with respect to severance?
Well, I think that's probably the highlight because the general rule up till that stage, it seemed to me, was that you were limited with respect to perhaps the practical situation where you had a confession of one that implicated the other. But they seem to have stressed in the Chaloner case that they would take a look at the balance of the evidence. And if it in fact was extremely weak, then that would be a factor to be added, and that they seem to pay considerable attention to that, and in fact, of course, ordered a new trial in the Chaloner case.
But would you agree that it seems to place a fairly high standard on the test that has to be met before you're going to ensure severance?
Well, it seems to me that gradually the courts are taking into consideration that their duty is not to convict every accused person. That they really seem to have as an object of the criminal law that we are trying to maintain and convict just enough people to keep our society going and to keep and maintain law and order. Now, if they permit the courts to be clogged with these bloody conspiracy cases, and the cost is such that society can no longer afford that type of trial, then they're going to have chaos. And accordingly, it just seems to me that they're starting to nibble at the edges and try and cut it back so that you get back into focus of what the true object of the criminal law is, to keep our society well ordered enough that we can survive.
A little crime is good for you, particularly if you keep away from the man at the top, I think is what was said.
Nicely put.
Once again, he still doesn't understand the problem.
Perhaps we could turn then to the question of multiple conspiracies, the possible defense that used to be available of checking the indictment and considering whether or not, in actuality, it was a number of smaller conspiracies as opposed to one conspiracy contained in the indictment. In terms of the state of the law now with MacDonald and Cipolla, is there much scope left for that type of possible defense?
Well, I wasn't in MacDonald, but I was in Cipolla, and I can tell you that as far as Charlie Cipolla was concerned, he had the full benefit of the jury system. The only piece of evidence against him was when he walked out of a washroom. He was sitting in a car outside a washroom, and a fellow walked out of the washroom and waved at him, and he drove off. And the jury out for a considerable length of time on this, and in those days, the police weren't too adverse to questioning juries after the verdict, and I was advised by a member of the RCMP that it was 11-1 to acquit my client, Charlie Cipolla. But the man that hung out was the foreman, who just by chance happened to be with the Judge Advocates General branch overseas during the entire war. And Charlie did 20, or as much as he could. He died in jail. But I think that the multiple conspiracy problem now whips over to the case of Catroni, Violi, and Papalia, and it seems to me that there is a very, very restricted view on that aspect of it now. I don't think any longer you can just take a quick look at MacDonald or Cipolla and say it falls in one of those categories. I think you have to look further and see if you can go through the mental gymnastics they did in the case of Violi and Catroni and Papalia, whereas you recall in that case, on the one side was a fellow by the name of Schwartz and a fellow by the name of Papalia, and it was alleged that Schwartz obtained money by extortion and shared some of it with Papalia, purportedly for protection, because he, Schwartz, used the names of Catroni and Violi when he was requesting the funds. So this allegedly occurred in the Toronto area, but they had some wire alive in Montreal at a time when the police knew nothing about using that sort of thing, and it never existed. But in any event, they resurrected it before they passed the Privacy Act, and it showed about a year later they had some discussions between Violi and Catroni in Montreal. So then they, at 18 King, used their ingenuity, and they rolled it all up into one conspiracy, and they decided they'd try it in Toronto, where the press coverage is a little better than it is in Montreal. And after fighting it through trial and the Court of Appeal, they got up to the Supreme Court of Canada, where they suddenly discovered that, well, you take a look at the indictment, and it alleges a conspiracy, and if you can get part of that conspiracy proved, you'll presume that the conspiracy that they're really referring to that indictment is the lawful one that they convicted on in the province of Ontario, and accordingly Violi and Catroni are out. Violi's under the ground, and the old man's still walking around. So I don't think you can just look at McDonald and Cipolla anymore.
Your Honor?
We should, I think, distinguish between what Clive has just been talking about and whether or not you can combine in one count of conspiracy several illegal acts, and it's very clear that I think you can do that. That goes back as far as Mr. Justice Cartwright's judgment in Cox and Patton. For example, that the objects were fraud and theft. But the more important, the area that we have been discussing, that Clive has discussed, is really turns out finally upon the evidence. And if on the evidence two conspiracies are proved, or three separate conspiracies, then obviously there cannot be a conviction. And you don't know until you've heard all the evidence, and that's because of the nature of this beast of conspiracy, where all of this wild evidence of association and the other matters that have been already touched by in the evidentiary problems all come in, and it is only at the end that a judge can decide whether the Crown has made out its promise given at the beginning. Oh, it'll all be tied in at the end, Your Honor. So, all right, provisionally, we'll let it in. And you don't know until all the facts are in. It's a practical problem.
Well, I think, Your Honor, that places an extremely heavy duty on the judge at that stage, because if you have a situation like McDonald and 15 others, if you could find perhaps that the Crown had established at the end of its case perhaps an agreement with respect to 2 out of the 15, then the onus would fall on the trial judge to make a decision at that stage, and it seems to me that's a pretty heavy onus.
It is a heavy onus, but if you ask Mr. Reisman, it was discharged in the case he appeared in before his client didn't get to go to the jury.
He sat there for a long time, though.
He sat there for a long time.
Before we leave this, could I ask one other question? And I admit that I may be looking fondly back into the mists of antiquity when I ask this, the time when maximum sentences had some relevance in the court. But if you have a single conspiracy with several objects, all of which are indictable offenses, say ranging from break and enter a private dwelling to possession under $200, and the jury comes back with a verdict of guilty, on what basis should that person be sentenced? I'm asking the question, not answering it.
I think only the judge does the sentencing. Perhaps he should.
Maybe he should answer it.
That's a problem that occurs not only in conspiracies, but in many cases. An accused is charged with theft of a number of different articles. You don't know whether the jury has found him guilty of, depending on their value, of under or over. I recently had a case of attempted rape. There were the jury returned a verdict of indecent assault, but there were various acts of indecent assault charged, and depending upon how many of them occurred and which ones, the sentence would alter appreciably. And the judge is supposed to determine then the sentence from the facts. It's an inherent fault built into the system, and yet I don't see how we can get around it without asking questions of the jury and having the jury answer them specifically.
Well, I suppose, Your Honor, if there's ambiguity, you must take the view most favorable to the accused and resolve it on that basis.
That's right.
I would fear that might be the situation.
It might be the law.
Yeah, that's right. The only comment I'd make for the Crown is that then in drafting the indictment, care should be taken where the object of the conspiracy is itself an indictable offense. Make sure that you define it sufficiently to get the most you can. If it's conspire to commit the indictable offense of break and enter, make sure you put in break and enter and put in private dwellings. And
Preferably if it happened in a private dwelling.
well, yeah, of course, yes. And if, well, what the heck, put it in anyway.
Sorry.
Yeah, you put that into plea bargain, don't you? Isn't that what you said? And if it's theft, make sure you put in over $200, same with fraud and so on, so that it isn't open to the argument, well, it could have been under 200 or not a private dwelling.
Heather, when are you going to give Bill a chance to have a go at the judiciary?
In my very next line of questioning, since conspiracies are here to stay, perhaps on a less frequent basis, and whatever their complexities may be, the problem of the long trial is with us and probably with us for some time to come. As a practical matter, what sort of steps do you take, Mr. Mackie, to ensure that your jury panel is well aware of the fact that it's about to embark on an effort that may go some months?
I don't know really how you can get across to the jury how long a conspiracy trial is going to take, because I don't think you yourself, even with pretrial disclosure, knows how long it's going to take.
Well, a general rule of thumb is to get a guess estimate and then treble it. Isn't that correct, John?
Yes, there's a certain amount of truth to that, but so many times counsel will sit down, usually there's 3 or 4 counsel involved, and you all figure, well, 6, 7 weeks should do it. And then all of a sudden you've got your students out trying to get adjournments at provincial courts and county courts because you're now into your 10th and 11th and 12th week. But how you get that across to your jury, I don't know. I think the judge should be consulted prior to the selection of the jury. I think it should be discussed with the judge, and I see nothing wrong with the judge indicating that this is going to be a particularly long trial, maybe weeks, maybe months, and certain questions being put by the judge himself rather than defense counsel or Crown counsel, such as health. Can you sit for that length of time? Is it going to work an extreme hardship on you? Questions of that nature, then indirectly you get across to them that it's going to be a long time. You're going to clear those jurors, and perhaps the judge will be broader in his aspects of allowing a juror to be excused. A man just recently on one night Clive and I were on had a heart condition. Then you've got to look at the holiday season because you find that there are certain religious groups that need certain times off that disrupt the jury. You want to clear that because you want to get ahead with it as quickly as possible. One thing that I think is a good thing is if the judge would indicate to the counsel whether he wants a full 5-day week or whether he's ready to let us have 1 day off to try and bolster what will be a failing practice as this goes on. That way I think that you get across to the prospective jurors that it is going to be a lot.
As a defense counsel, and just playing devil's advocate for a moment, do you ever fear that a judge announcing to a panel as a whole that a trial may take a number of months and any jurors who aren't able to sit for that length of time and the general stampede that exits from the courtroom or raises their hands thereafter may leave you with a less than satisfactory remaining panel?
I don't think so, because I'd rather have those that want to stampede and get out, than have them sit there and say, those bastards are keeping me away from my job, from my home, and building up an antagonism that you don't want to build up. It's none of your fault that the Crown decide to lay a conspiracy charge. It's got to be faced. I personally would rather be without a jury on a conspiracy charge.
Why is that?
Because as we go along, usually they involve wiretap, they involve similar acts, they almost invariably have documentation up to here, and I'm not so sure that the jury can follow that. You get to the end, and I think what happens is that the judge then tries to separate the issues and whatnot, and he makes a comment on the facts, and depending on your judge, they look up and they say, hell, I don't know what really went on, but he's a judge, so he must know what he's talking about, and be swayed very greatly as to the comments that the judge makes on the facts, which might be quite unfavorable to the defense.
Well, why would you want him alone then?
Well, for the simple reason that he's more likely to give an opinion or give his judgment based on his interpretation of the law, and you might have a good grounds for appeal, whereas the jury if it renders a guilty verdict, you go to the Court of Appeal and they look at certain decisions. Borman decision says, well, the judge read them exactly what the Borman decision said. He certainly wasn't at fault there. I'd rather give the judge a chance to make a fault and give me an appeal.
Your Honor, I took it from your nod earlier that you're in agreement that it's a good idea to advise the jury panel and you and your brother judges would be prepared to take that on in the long trial?
If I might, I think it's something that we've touched on now. The problems of the long trial affect everyone. The lawyer in his practice and most counsel who practice criminal law practice alone. Their tremendous problem is to be away from their practice for a long period of time. It could disappear in that time. The jury has the same problem again. They are taken away from their jobs and ordinary pursuits for a long period of time at a ridiculous recompense, even though it's been increased. There are other problems that appear. In a lengthy trial, after about 4 weeks, they start to appear. Unusual conduct on the part of counsel to opposing counsel and counsel to judge and vice versa. Open quarreling, disregarding of rulings of the court, and persisting in asking questions that have already been ruled upon as inadmissible, arguing after rulings are made. Now, these are never a large problem in a 3 or 4 week trial, but in the long trial, after the 4th week, something happens to people who otherwise would not conduct themselves that way. And I think if there's one purpose to this panel tonight is to discourage you all from participating in a long trial. You require, if you are not in good health, if you can't be patient beyond endurance, if you can't stay in good humor, don't take it. That applies to the judge, to the jury, and to counsel. And it is very important then to put to the panel, and to do it where, if counsel care for the judge to address the jury on that and then question each of them before they're sworn, or if they wish to take that one point and do it by challenge for cause, it is one of the most important points in the trial. You have to end up, after some months, with at least 10 healthy, happy jurors. And after the fourth week, the tremendous public cost that has been invested and these feelings that arise, speaking from a judge's point of view, lead you to worry about only two things: ending up with 10 healthy, happy jurors and not committing an error so gross as to obviously call for a mistrial. The other ordinary rulings you just quit worrying about, and you don't give a damn whether you're right or wrong.
What about the problem with the jury in statements and voir dires? The jury being impaneled,
Well,
appearing briefly for a day or so, and then being recalled a month or two later.
yeah, I think that's frustrating, but we haven't had the amendment yet. I think many of us would support the concept that before the jury is impaneled, that there should be a dealing with admissibility of, for example, confessions, admissions, statements that have been made, questions such as recent complaint, questions of similar acts, so that you don't get these people coming in, reach an issue, send them off for 2-3 days, bring them back, they're up and down and out of their seats 2 and 3 times in a day, quite apart from their coffee breaks and lunch, and they begin to get annoyed. Now, I don't think there's too much we can do about that until something is enacted, but I think that there is a real need for the hearing of the admissibility of evidence that must be determined in the absence of the jury. I see no harm in getting it done before you pick the jury. You then have your ruling, and you then move right into the trial, and you can move along, I think, at double the speed that you could otherwise.
You're absolutely right, and it's been before the Canada Law Reform Commission since at least 1976, and approved by every commissioner that has sat on that commission. And we still don't have the procedural amendments required. That's where some of you, through the Canadian, Ontario and Canadian Bar, could put some pressure to bear.
What about the participants in a long trial? Covering for each other or supplementing each other? Do you believe there's a place for counsel spelling off other counsel, or having a junior briefed in a major trial, or two crowns appearing on a trial, for example?
That gives me an opportunity then to give some suggestions that a number of us who have had long trials have agreed upon. Judge O'Connell, Judge Barnes, the late Judge Hansberger, that there be a pre-trial conference, and that it should be some weeks before the trial. That you discuss the matter, for example, that we have, has been mentioned, the careful choosing of the jury. That provision be made, depending on the length of the trial, of at least 1 day a week, and at most 1 day a week, and at least 1 day every 2 weeks if it's a shorter one. But I would suggest that if one knows that it's going to cover at least 2 months, that it should be once a week, and that date perhaps or often is Friday, so that the counsel can look after his other cases, his office, his other affairs, so that the jurors as well can be about their own business on that day, so everybody can have a rest. Why should they work 5 days a week for that length of time? That there be a provision for 2 crowns. I was fortunate to have that in one long trial, Mr. Frankel and Mr. Dambrot. They could spell each other off. The only thing is that only one of them, of course, could cross-examine a witness. They couldn't both take their whacks, and only one of them could go to the jury. But we had that continuity there, and it provided if one of them were ill, for example. The same for counsel. Counsel should provide for someone who could spell him off at those times when he can be assured that the evidence will not be seriously or at all affecting his particular client, and he can be excused and have some young junior counsel take his place, because we can't leave the accused without representation. Another matter that in the pretrial conference could be the vetting of the issues of statements and wiretaps, and considering what the length of the voir dire would be, so that one could advise the jury with some reasonable assurance how long they'd be away before we got to the trial. Another suggestion that we would have would be that motions, now I'm not talking about objections to inadmissible questions, inadmissible evidence, but motions such as to quash motions for severance, motions for commission evidence, those serious motions, that they should be in writing and they should be on notice to all other counsel, and they should be dealt with at the end of the day, say at 4 p.m., so as again not to waste the jury's time. And there should be everybody being officers of the court, an encouragement to full discovery, at least of documentary and demonstrative evidence. And little things like seating arrangements, when you have, they appear to be little things, they aren't. The succession in which counsel will cross-examine and go to the jury, that generally follows the happenstance of the way that the accused are named upon the indictment. And I think that from our common experience, that those are things that we think would be of benefit to the judge, to counsel, and to the jury.
But you know, Heather, there's an even more practical difficulty in these long trials. And that, I think, every lawyer is concerned with and every client is. And the first thing that the clients ask is, how much is this going to cost me? Now, unfortunately, I don't get the clients that are millionaires. And
Sure aren't when you're through, anyway.
the Crown's in a unique position. Their paycheck comes in no matter how long the case takes, and they can go on and on indefinitely. But you've got a client coming in, and he wants to know how much this is going to cost him unless he's on legal aid. And I think he's entitled to an answer. But you've got to know yourself, because you go quoting a fee, and your client is going to run out of money before that trial is over. You're sitting with an office with overhead to pay, probably an overdraft at the bank, plus a loan, plus the receiver general gapping at you, and you've got no income coming in. Now, I think this, to the average practitioner and to his client, is perhaps the biggest problem of the long trial. If he's got all kinds of money, you've got no worry. But very few people have that kind of money, and something's got to be done so that the fees can be set realistically.